Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. And in this episode, we're going to talk about an interesting legal topic. And just a disclaimer before we get started that Justin and I aren't attorneys. So this episode is for informational purposes only. Consult with an attorney if you feel like you have a takings claim. And that's exactly what we're going to talk about today, Justin, are government takings, regulatory takings, how that can apply to oil and gas and mineral rights, because there's definitely been some regulations and proposals in different states that could enter into this territory.
You know that, Matt, and it's really an interesting concept, and you kind of hear it thrown around in mineral rights of, they can't do that. It would be a takings claim. But the regulatory takings is really a much larger topic than just mineral rights, and you see it applied in the law in different ways, not just with property rights.
Yeah, that's exactly right. And of course, we're just going to focus on the property rights side today because that's really what applies to minerals and royalties. But just to set the groundwork here, regulatory taking is a concept in law where a government regulation limits the use of private property to such extent that it essentially can't be used by the owner. And whether that is like actual physical use or if it's that it takes away the economic use of that land. And we'll give a couple of examples of where this has occurred in the past and how the Supreme Court has ruled on this. And this is all sort of governed by the Fifth Amendment to the U.S. Constitution that states that such taking of private property for public use cannot occur without just compensation. And it falls upon the Supreme Court to decide what constitutes a regulatory taking and determine how much compensation is required. So, Justin, you want to dive into that Fifth Amendment clause and talk a little bit about some of the Supreme Court history there?
Yep, absolutely, Matt. So again, it comes from the Fifth Amendment, which states, nor shall private property be taken for public use without just compensation. And it underscores the balance the government must maintain between promoting public interest and then respecting private property rights for owners. Throughout history, Supreme Courts dealt with various cases that touch on this principle. The court has sought to distinguish between government actions that will fall under two distinct categories. The first falls under the umbrella of eminent domain, where the government moves to take possession of property because of its need for public use. And then the second category are those that involve regulation of property to prevent its use in a manner detrimental to the public interest. Courts also dealt with cases involving zoning and land use controls, environmental regulations, and other forms of governmental regulation of property as well. And Matt, the concept of eminent domain, it's a phrase that's commonly used to denote the inherent power of a governmental entity to take privately owned property and convert it to public use. Under the power of eminent domain, the government may take private property, again, for public use by paying the just compensation. And Matt, we see this in highway expansion. This is something that is quite often used. And even though eminent domain is allowed, the government doesn't have free rein to just take what they need. For example, before exercising that eminent domain to acquire rights of way for that interstate highway system, certain steps must be followed in accordance with federal regulations and statutes for a given public use to be served by taking the property interest. And so, Matt, this is a concept that, again, is regularly used. And Matt, do you want to talk about that second category, which kind of applies more to what we've seen in the news lately, which would be placing restrictions on what people can do that would take the value away from that property?
Yeah, that's a great summary of eminent domain. And that is the very obvious, physical example of taking where you're not able to physically occupy that piece of land anymore because now there's a highway on it or the right-of-way goes on it. And so now it's government property. The second category of government takings, again, typically involve placing restrictions on property to protect the public interest as well. And this is sometimes called an inverse condemnation, in which a private property owner initiates an action against the government, claiming that a property interest has been taken without just compensation in violation of the takings clause of the Fifth Amendment. And again, these are sort of two distinct legal issues that these types of takings bring up. And in the case of the regulatory taking, it usually results from things like land use controls, or like Justin said, regulations that place restrictions on land use, which then impacts property value. And this type of taking is especially relevant and impactful for mineral owners since we're dealing with ever increasing regulations which seek to limit the ability to develop oil and gas reserves. And by virtue of that, if you can't develop the oil and gas reserves and receive royalties from those mineral rights, then a taking would have occurred, right? If you're not able to get the financial benefit that you would have gotten from that piece of property had those regulations not been passed. So that's the theory behind it. And we'll talk about a few examples of where this has been applied in the past, because this is something that actually has been tested in the courts. And the Supreme Court has ruled a few times around minerals and royalties, and mostly on the mining side, but we'll talk about the potential application and some of the things that have happened with the oil and gas side as well. Before we dive into that, Justin, there's a concept that's important that is around the Tucker Act. And this is actually a critical part of whether or not the government can be held liable for something. And so do you want to talk about what the Tucker Act is and kind of why it's important here?
Absolutely, Matt. So to kind of set the stage here, in general, the government is immune to lawsuits, and it's a general rule. And the Tucker Act was a way that it exposes the government to liability for certain claims. Specifically, the act extended the original Court of Claims jurisdiction to include claims for liquidated or unliquidated damages arising from the Constitution, including those taking claims under the Fifth Amendment, a federal statute or regulation, and claims in cases not arising in tort. And Matt, for regulatory takings that do not fall under their formal eminent domain proceedings, the Constitution still requires that just compensation be paid. And Matt, that's where the Tucker Act really becomes important, because it allows for claims for compensation against the federal government where really the government is immune to those lawsuits outside of that purview.
Yeah, that was an interesting thing that for this episode, it's definitely, something where you hear of lawsuits, like that Camp Lejeune lawsuit where the soldiers that were drinking the water that was contaminated or whatever. So there's definitely times where the government is liable for certain actions, and that Tucker Act, gives very specific, requirements and when you can go after the government for, damages and things like that. So, back to mining and mineral rights, what we're wanting to focus on here is examples of regulations where mining or oil and gas drilling that have been passed that the courts have then ruled they went too far in depriving the mineral estate from the value that was underlying that piece of property because of the valuable minerals that existed there. So for several decades following the explicit recognition of the federal government's eminent domain authority, the Supreme Court held that regulations designed to secure the common welfare, particularly in the areas of health and safety, which we're really seeing today being the big focus around why they're trying to stop oil and gas drilling, is on the reasons of it's bad for the environment, bad for health and safety. But back in the day, before they sort of dug into these first few cases, that area was not considered a taking. So if there was a restriction that was placed on a piece of property or land or use, and it was due to the benefits of public health and safety, then sorry, Charlie, you weren't subject to a takings claim. That changed in the 1922 decision, Pennsylvania Coal versus Mahone. In the Mahone case, the Supreme Court examined a challenge brought by holders of subsurface mining rights against a state statute that prohibited subsurface mining for coal in areas where it might trigger subsidence. And the subsidence is just the result sometimes if you extract minerals like in a mining claim like this one, where the removal of that material below the ground causes the surface to sink a little bit. And what the concern in this case was houses and other structures below that coal seam. And so those houses were built. They said, we want to place a restriction on the mining beneath this town that's popped up or whatever. And the court determined that the statute made it commercially impracticable to mine certain coal, and it essentially had the same constitutional effect as appropriating or destroying the subsurface estate. So basically they took away the value of that because that coal company, Pennsylvania Coal in this case, couldn't extract the coal and sell it and get the benefit from the rights that they had acquired. So Supreme Court concluded that while property may be regulated to a certain extent, if the regulation goes too far, it will be recognized as a taking. And they found that a taking had occurred in this case where the government action rendered the subsurface property interest basically valueless. So, this is an interesting one, Justin, because they sort of set the precedent that, okay, regulation can cause a taking with respect to the subsurface property rights. So this is an important one from like a mineral and royalty owner perspective, because it was sort of the first landmark decision that the court said, yes, then you can have a regulatory taking that can impact property value and generate a takings claim that would be valid. And again, this is really important here. A regulatory taking is deemed to have occurred if they deny a property owner any economically viable use of his land. So just like a physical taking, like the eminent domain example that Justin gave, where they took your parcel of land to expand the highway and they compensated you for it. Well, the same kind of compensation is required under the Fifth Amendment for those regulatory takings, where there's an economic impact, not just a physical occupation of that land. And a couple other cases that popped up, I'll mention them in case anybody wants to go and do some research and nerd out on the legal side of things. It's Agins, A-G-I-N-S, versus City of Tiburon, and also Lucas versus South Carolina Coastal Council. And that South Carolina Coastal Council one's interesting, Justin, because there was a regulation that prevented him from building on this piece of property that he bought, which is like an oceanfront property in South Carolina, perfect place to build your retirement home. Well, they said, no, we were going to protect the dunes or whatever it was. And then he couldn't go build his retirement home. And so it was determined that he had suffered a taking. So it's different uses, can be like surface rights, can be subsurface rights, but that whole regulatory taking is an important concept for mineral and royalty owners.
Yeah, absolutely. And another important case related to natural resources is the Whitney benefits versus the United States from the 1990s. In this case, it was found that the United States government took a mineral estate, a Whitney coal, from the Whitney benefits and Peter Hewitt Sons Company upon the enactment of the Surface and Mining Control and Reclamation Act. This act limited Whitney from being able to mine on their land, and as a result, they were awarded the economic value of the coal that was placed off limits after the fact. This might have been elevated to higher courts, but from the U.S. Appeals Court ruling in 1991, they were awarded $140 million for the economic loss resulting from the regulatory takings. And so, Matt, we have a lot of precedents that's been set with these previous cases. Even if it's for the greater good of the environment or it's for a regulatory reason like that, there's still the loss of value on that property. One of the measures that the court used in determining if a takings may have occurred is if the regulation does not substantially advance legitimate state interest or denies an owner economic viable use of his property. And again, Matt, does it deny economic viable use of the property is really the key there.
Yeah, that's a great point. Now, let's talk about oil and gas, because that's what we're really interested in as far as minerals and royalties is concerned with this show. So I couldn't find any takings claims related to oil and gas restrictions that were kind of widespread. There was a couple of examples that I found that talked about where they had built a reservoir and they basically limited the ability to drill straight down. This was like conventional drilling where you have that particular tract of land and that you need to drill from that tract of land in order to access the oil and gas that's in that specific location. This is sort of prior to the advent of horizontal drilling, and where the most economic and the most effective way was to drill vertically. And what they did is they took away that right of that company to drill wells where they were placing that reservoir. And they found in some cases that a taking had occurred, in some cases a taking hadn't occurred because there was directional drilling technology and they could drill from the edge of the reservoir and then access the oil underneath. But, there's definitely precedent for oil and gas, but it's almost akin to the eminent domain concept where they built the reservoir, now you can't access the minerals underneath it. It was more I can't physically access it type of a situation, where large widespread regulation like the state of New York in 2014 banned hydraulic fracturing. And this is something that I couldn't find where there were mineral owners that had sued the state for a takings claim. And that's kind of surprising to me because New York overlays part of the Marcellus Shale. So that's where Pennsylvania, Ohio, the Marcellus, and the Utica is a ton of horizontal drilling going on, lots of natural gas, and that extends into parts of New York. And again, by the fact that they've banned hydraulic fracturing, it makes it not economic to go and really not possible to go and extract that gas. In doing the research, a couple of things in terms of determining the compensation. The traditional approach is to base damages on the market value of the property at the time of the taking, and with minerals and royalties, because there's a wide range of potential outcomes, right? So if we're trying to determine the value of those minerals and royalties, we need to look at what would the timing have been when a well would have been drilled to when we would have started receiving royalties. And then from the time value of money, you discount those future cash flows back to today to figure out the market value of that at the time of the taking. Well, if we don't know when that well was going to get drilled, then you have to make certain assumptions. So it's probably going to be a negotiation then in those types of takings claims where you're having to figure out the range of potential outcomes and what the most likely scenario would have been. And an interesting thing, like I said, with those cases where they built those reservoirs, some of the thought process with the court appears to have been alternate uses of the surface. So in cases where the mineral owner had the surface rights and the minerals, they said, well, you can still use the surface for other things. And so you haven't suffered a taking. Well, with severed mineral rights, that doesn't apply because it doesn't really matter, especially with horizontal drilling, what happens on the surface, because you can be 2 miles away, drill a horizontal well and access the minerals under that tract of land. So that concept, I don't think would apply, going forward, to the extent that the takings claim would have been related to horizontal drilling, because in that scenario, you can be several miles away and not have to be physically on that particular tract. So Justin, you want to talk a little bit about the regulatory climate and some of the things going on, and maybe we could dive in a little bit more into that New York hydraulic fracturing ban and some of the stuff that went into that and how they justified that.
Totally, Matt. So we're here in Colorado, and the Colorado Bill SB 24-159 is one that really stands out. So the bill requires the Energy and Carbon Management Commission to adopt rules to cease issuing new oil and gas permits before January 1st, 2030. And Matt, I think this is really the reason we've been talking about this a lot lately is some of the states and their moves to ban oil and gas. And, since the value of those underlying minerals is directly tied to future revenue generation capability from leasing, and when a well is drilled, royalties received from that oil and gas that is produced, if you take away that revenue generation ability, then it stands to reason that a takings claim could occur. And, it's kind of the question mark of if that was something like that was to really go through, would it just be an onslaught of lawsuits to do with takings? The value would likely be dependent on the location, from a very small amount to tens of thousands of dollars per net mineral acre, Matt. And I would imagine you would see class action lawsuits where many of these mineral owners all kind of group together and move forward in this. And again, New York passed regulations banning hydraulic fracturing under the guise of protecting public health due to significant questions and risk to public health, which are as of yet unanswered. And this was by Howard Zucker, for the Department of Health Commissioner in 2014. And Matt, you're kind of limiting what value you can get from that property, and it creates a situation where the government should be compensating owners for the lost value in that property.
Yeah, and that New York case is particularly interesting to me because I'm very surprised, to your earlier point, that there hasn't been just a wave of takings claims from New York mineral and royalty owners. And especially since 2014, we've learned a lot more about the lack of negative health impacts from hydraulic fracturing per se. Hydraulic fracturing in and of itself is not necessarily cause health issues. And that's been proven objectively by several independent studies that have been done. So the fact that, especially since when they passed this regulation, they had said, well, we think there may be potential health risks. And this was the time of that movie Gasland, which was not based on reality. They had a bunch of things that they made up in that movie. So that influenced the mindset of the public at the time. And we're still dealing with those after effects to a large extent. And so if they're saying that the public health risks are unanswered, in my mind, if you're having to prove definitively that it's for the public health that you can have a valid taking. And just by virtue of what that guy said, it doesn't seem like they had a valid claim to take that away from those mineral and royalty owners, the economic benefit they would have potentially had from drilling on their minerals. And so since then, there's been no horizontal drilling for gas in New York because you can't hydraulically fracture those wells. And so it becomes impossible to extract gas in that case. So it's interesting, Justin, where you have those kind of ambiguous reasons that were given why there hasn't been just a flurry of lawsuits, and maybe they'll come at some point. But to your point, I do think if a state were to just de facto ban new oil and gas permits, then there would definitely be some takings claims from affected mineral and royalty owners. I think there needs to be a line drawn in the sand that that's not acceptable to take that value from those owners. It would be billions of dollars, and I think it would be cost prohibitive for them to pass regulations. And again, from a health and safety standpoint, there's lots of regulations in place from Clean Water Act, from ensuring that you're not going to contaminate drinking water when you drill through those aquifer zones, to the emissions side of things. And the EPA just passed methane regulations that limit fugitive emissions and require monitoring. So there are all these controls in place that limit the negative health impacts from oil and gas operations. So I think that balances that out and takes away that argument. So yeah, it'll be interesting to see how this develops. And that Colorado bill is, like we said in the news episode from March of 2024, it was a signaling bill. But whether it's California, Colorado, some other state, if they do pass that type of regulation, then I do think there'll be some legal battles that will ensue.
You said it, man. Yeah, and it would be interesting to kind of see the evolution of this, and what the precedent seems to be pretty clear that there could certainly be a takings claim that would be created by those regulations. But if moving forward, the federal government decides to get behind the states banning this, there would definitely need to be action and legislation on their side to kind of reinforce this and allow the Supreme Courts to rule differently than precedents. So it'll be interesting to see how this changes. Right now, it is a wonderful protection that mineral right owners have. And, I think bringing a claim against this could be no small feat. But when you get a state that bans it in entirety, all of those mineral owners coming together could have a lot of impact and a lot of power in a lawsuit.
Yeah, there's definitely power in numbers. And like we always say, stay informed on the legislation that's being proposed in your state. Speak out to your representatives if it is going to negatively impact your property rights. And this would be a good time to plug NARO, Justin. I think the National Association of Royalty Owners, it's the only national organization that advocates on behalf of mineral and royalty owners. Both Justin and I are volunteers on that organization. And it's a great way to stay updated on things that are happening with respect to minerals and royalties, and making sure that you are notified when there's something that you need to speak up and let your voice be heard. So to find out more about that, you can find a link to the NARO website in the show notes. But yeah, I think government takings, again, this is a pretty technical legal area, and reading through these articles, and we'll put links to all these references that we found in the show notes so you can do some research on your own if you want to learn more. But definitely learned a lot, definitely a lot of complexity with this and to how it's applied. The constitutional attorneys are turning in their graves, hearing us talk about this probably, but hopefully it's at least given you enough to be dangerous and understand the way that it's applied and some of the case law and how that has gone in terms of ruling in favor or against takings claims. So
you said it, Matt. And as we mentioned at the beginning of the show, don't give us legal advice. We're neither one of us are attorneys, and it's for educational purposes. But I think that's a pretty good overview of how it may apply to property rights.
Thanks again for listening, and thanks again, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.